Alright, ebusia for any day kwan so ma me chia na me mo akwaba emfa omra possible multimedia. Any day kwan so ene ne dey kan we ne channel is YouTuber nsa edan san me be so bejebre no wa share videos no amana kwa wie so share and wa like wa comment wa subscribe we and wa share content no and also recommend the channel no ama uni ebi so enya videos ni bi ahwe obi ebusa se mpempren eden ena possible multimedia ye wo edema ahwefo ebusia se mobeka ye enche bia na me de update bi efa ambulance trial involve honorable ato Forson any Richard Jakpa against the state. Mpempe ameno ka say de amadebo a efi Supreme Court eba no emu hwam yie pa. Ise me de bia na me beka nsem e de afa ambulance trial no ho anase me be kyerem adwen e de afa ho de ameka ne say enyoma mienu yasoma se kɔ na kɔtɔ de bibi kɔ na kɔtɔ bibi fa bre oman no okɔtɔ ba ye no ye say to 200 o de 30 pe ene ba ye 30 na o de ba ye no ye ba ya ye be inspect ye no nipa no inspect ye no e kan so say these vehicles are not fit for purpose and so therefore Ghana na small sign fa kɔ na GAC ka fa bre ye. First of all, you can say to 200 and I will 30. 170 no MI. Sikana eka yen so a eno so ye hu the whereabouts. And asem no ekopie mu ewo court. Godfrey Dame Attorney General eno mo pem so be se nei yenya update bia. Current update abetodwa. And it says Supreme Court finally akasa ama Richard Jakpa. Any minority leader needing Eddie Honorable Ato Forson. Ehun akaye de bia na meka say enoma mienu it's about time say mpeni for ye di bi be scapegoat fasika ne bra wan fa ma ye de mra ni wedi anase mra ni wedi na ye do akoto bebia wo se fata because entumi ma say mpenifo a ye beto aba e de amamo no na mo san a kire de amomo pe ebusia we eni se bebre na etwa gusesia concerning the ambulance trial mpempe amenu ka say de finally Supreme Court akasa yenkwaje nsem no munchemu ne wie na bibi che wadwen a huni se aha possible multimedia obetumi feel free na wacha wadwen comment section no ase yakopon insha ye nyina.
In the Superior Court of Judicature in the Supreme Court of Ghana Accra nipa the signature shekrata yase ya ne stamp process so eye the Chief Justice yamame Gertrude Tukonu na a criminal appeal number J13 date shehoye 8th August 2024 the Attorney General Godfrey Yabadame versus the state way appeals document ya Supreme Court acknowledging receipt of it ya free the office of the Attorney General. Appeals document efa case bi ho. This is the appeals document on the case involving Dr. Kaisil Ato Forson and businessman Richard Jakpa. Now, on the 30th of July 2024, and at the Court of Appeal, it delivered a 2-1 split decision in favor of minority leader, former Deputy Finance Minister Dr. Kaisil Ato Forson and businessman Richard Jakpa, acquittal of no wrongdoing in the 2.37 million euro ambulance case. Nipa imi file a case of no submission. In that ambulance case, High Court Botugui established a prima facie case. The case noa. My daughter case Lato Force a close the case. Ni bejina Richard Jakpa. But now Omadi kind of file an appeal. The Court of Appeal. So still yano. Submission of no case in the appeals court to sign review musan so mu boni bi omaye ense so mu jina court na yatoto to omano. Eno na Court of Appeal no court trans judges miensa court trans emu mienu agitu mu se eye no kre. Omo wiwe mu nyina di adanse se submission of no case ni e wo se gina na high court no ye mfonso enti Dr. Kaisil Ato Forson and Richard Jakpa and form hunkodi. The Attorney General Emma Ghana for nyina te say case this is not the end of it. Obeko appeal na appeal na okon he is moving straight to the Supreme Court no the asem na ko down wo mo na wa kire adekodie ntia ensese the acquittal of case Lato Forson and the Richie Jakpa ensese eden a hold the test of time because ruling no awon so akenkan bi no enfonso bebrebe e wo ho na said the beya obeti case na see making kind the appeal document dia kire ma said the beya obehunu said the case ni si ko na si ba no me say to me boase na ma summarize the entire decision of the Court of Appeal ye 2-1 the obia kan ye ntia ne omu gina so e rule say submission of no case no enyina na Dr. Case Lato Forson and Richie Jakpa emfa no nkodi any statement Attorney General enso e dia hye ne appeals document mo no so kire say Supreme Court nso hwe so na sa appeals court ruling no ono nso yen set no aside say the bia be hunu say the case no esi eko. Now judge for me and son omo tenase e wo the appeal case no so no 1 Justice Kwekuti Akabuafo. 2 Justice Philip Bright Mensah. And 3 Justice Alex Poku Echampo. These were the 3 appeals court judges. Yeah, omo a rule on the submission of no case and the possible and answer the acquittal of Dr. Case Lato Forson and Richie Jakpa. Judge near will declare Justice Kweku T. Akabuafo. Ninsem now kind in Nana Mabona Tofan or say, based on my analysis and in fidelity to the law, I am of the opinion that the appeals filed by both the first and third appellants should succeed. In the result, I would allow the appeals and the ruling of the trial court dated March 30th, 2023, calling on the first appellant and the third appellant to open their defense in respect of the charges in count 1 and count 5, hereby set aside. Also, the call on the third appellant to open his defense in respect of the charge in count 3, set aside. In their place, an order upholding the submission of no case entered for both the first and third appellant in respect of those 3 counts in the charge sheet is issued. Consequently, both appellants are hereby acquitted and discharged. Reasons when Justice Philip Bright di nyina na yepe nti meka nyina bom na makan baako. Now, they both made ono and Justice Philip Bright Mensah both made some conclusion, including the fact that the prosecution, which is the Attorney General, did not establish a prima facie case against Lato Forson and Richie Jakpa, and therefore the High Court erred by upholding the argument of the state, according to Justice Kwekuti Akabuafo, Justice Philip Bright Mensah, the Attorney General, and to me I established a prima facie case. Say they rejected the case of the Attorney General that Lato Forson issued the letters of credit without the authorization of the then Finance Minister, said Jakpa, noting that evidence adduced by confessions from both Lato Forson and said Jakpa indicate that his boss, said Jakpa, was very much aware of Lato Forson's actions, and that he, said Jakpa, gave Lato Forson the permission to issue those letters of credit. And the judge for me the other kind said Attorney General say Lato Forson issued those letters of credit without authorization, according to Judge Simienu and yes sanity. According to Omokasa say Lato Forson no one said the dance here or court to say, and then the 2 means soon the sign. Sansuna said Jakpa yana or your finance minister, or no so Lato Forson friend as a witness, or no so be the dance here or court to say, or no, and the man Dr. Case Lato Forson to me say on issue those letters of credit. And until on J, you will say Jakpa some no 2 munu precope. So you cannot come to court and say that Lato Forson acted without authorization. This is according to the 2 judges. Ebiomo say, to succeed on the charge that the first accused acted without cause and authorization, the best evidence to establish it was for the prosecution to have invited the substantive minister, Honorable Sir Tekpe. Having regard to the evidence, it was done on his blind side. We are of the considered opinion that Sir Jakpa was a material witness whose evidence would have decided the case one way or the other. Failure by the prosecution to invite him to testify that he did not authorize Forson was fatal to the case of the prosecution. For the law is well settled that if there is a vital point in issue and there is one witness whose evidence would settle it one way or the other, that witness is a material witness that ought to be called to offer evidence. There is that evidence on record in our present case that in the course of investigations into the matter, Honorable Sir Jakpa is said to have volunteered a statement to investigator, prosecution witness 5. In this case, that seems to suggest that the request for the establishment of the LCs was done on behalf of the Ministry of Finance. For purposes of clarity, we reproduce excerpts of the statement, that is Exhibit 5, upon receipt of the Attorney General's opinion. Ministry of Finance proceeded to establish the LC. The letter noted that this was a valid contract. By this voluntary statement to the investigator, it means that Mr. Sir Jakpa was very much aware of the steps the first accused took in requesting the establishment of the LC to avert the imminent action against the government of Ghana for breach of contract. And this advice was given by the Office of the Attorney General then. Now, there is no iota of evidence on record to show that if indeed the letters the first accused wrote were done on his blind side, Mr. Jakpa repudiated the same or he queried the first accused for what he did. It cannot be lost on this court that it is the Ministry of Finance that has the sole power and or duty to request for or authorize letters of credit to be established on behalf of government ministries and departments. The prosecution witness 4 in his evidence to the trial court as appearing on admitted that that was the right procedure to follow. In the result, we roundly disagree with the learned trial judge to have rubbished or rejected Exhibit 5, saying that the author of that statement has not been subjected to cross-examination. I think that the lower court fell into serious error, occasioning a gross miscarriage of justice to the first accused because his duty is only to raise doubt in the case of the prosecution. On the authorities, if there was a doubt in the case of the prosecution, it shall inure to the favor of the accused. Consequently, we allow the appeal on count 1. Enti omu nyina so a omu di ejina so nyina ne say Sir Jakpa ejitu mu say ono na ma Dr. Kesila to Forson to me. Na se wani antumu pa krata bia no hono mu ekire se Sir Jakpa ekwari ato Forson e wasa na mo na wotu ye no. Krata bia no se dia dance say Sir Jakpa e reporto ato Forson wasa na mo na wotu ye in the issuance of those letters of credit. Hence, it means that Sir Jakpa was fully aware and fully in support of an amount of Forson too. And in the Ministry of Finance, it is the substantive minister that is held responsible for any other payment made. This is a take and to me and deny dia. It's just to force any money. Tina was a prosecution in fresh take. Na say take to me back catch court to say the ato force here no oni mo hwe. Nti omu do mususu say judge ni a wote adwamu eyem fonso e was ade no. Enna the other judge ono ejina mu no enso kire mu a or dissented to the views of the majority or rejected the submission of no case by Ato Forson. On the High Court decision to establish a prima facie case is absolutely in favor of that decision. Because according to Justice Alex Pokwe-Champo, Sir Takpan sworn to me and provided evidence be a chira say or no and my daughter case Ato Forson to me. Every single letter of credit involve payment piano. Nipa ni signature ne chassis Dr. Case Ato Forson. According to Justice Alex Pokwe-Champo, letters of credit in one day the issue, and 1 month the issue. Now a year over a period of time. Until all those period of time, where was the substantive minister of finance in Tia? Nina Ato Forson and a sincerity. On the other, or fully in support of the High Court establishing a prima facie case. It is say ankasa na appeals court no ruling no na etie. Na osha the learned attorney general Yewra Godfrey Yabodame appeal no so file ewie no say na argument ni say the court of appeal misdirected itself and committed error of law by ruling that a prima facie case has not been established against Ato Forson and Richie Jakpa. Enti Yewra Attorney General so chirimu appeals court 1 omo misdirected omo and omo sa yen funso emram funso say omo kire say Attorney General any High Court and to me establish a prima facie case anfantia Ato Forson and Richie Jakpa. Because according to the Attorney General, a new way and then the Attorney General and Justice Efiase was to me establish a prima facie case against these two accused persons for them to open their defense. Barako